Hi, everyone. Welcome to Let's Talk, where we talk about trust and estates and taxation. I am your host, Marie-Yves, Nadine Jean-Baptiste. I am the owner and CEO of the St. Eve Law Firm here in Towson. So I know last week we talked about, an update to the Estates and Trust article pertaining to the fees associated with the Register of Wills and different charges that they may impute or waive when there is an individual who, rather a personal representative who is looking to administer an estate there. Hi, Tanae. Just a few quick updates with our law firm. So she said the last week's summary was an increase in fees. It sure was. Inflation is real. So a little bit about our firm. So we have made some changes and we're no longer practicing family law. We still get a few calls for family law. If there's anyone that's interested in family law cases in any of the counties that we practice in, feel free to send us an email at info@steveslaw.com. We will go ahead and set you up with a referral. The firm has a referral network where, attorneys that we've either done work with or we're familiar with, we go ahead and we refer those cases out to them. And these are individuals that we trust with our own work. And therefore, that's why we send clients to them. Thank you, Camille, for putting that up. So moving on, like Tanae said, last week's summary was an increase in fees. This week, we are going to discuss, just quickly, of course, we don't have that much time, but today we're going to discuss House Bill 1049, which deals with Section 14.5-907 of the Estates and Trust article. And it's actually part of the Maryland Trust Act. So the discussion today is about possible amendments to the section pertaining to notice required by a trustee in order to obtain a release of liability for his or her actions while serving as a trustee. For individuals out there who do not know what a trustee is someone who is like myself. We are considered a fiduciary. A fiduciary is someone who is in a position of power and trust, that someone entrusts with either money, property, or person, and we are tasked with making sure that we do things by the book. And if anyone knows me, I do things by the book. I don't even cut corners for my own mother, and she is watching and she's probably laughing because she knows it's true. So fiduciary is supposed to do things 1000% by the book, and they're supposed to make sure that every single action that they take is in the best interest of the estate and the interested persons. So interested persons can be a creditor, they can be a beneficiary, they can be a spouse. It's just someone that stands to gain on some level, one way or another, from either the administration of the estate or the administration of the trust. Okay. So under section 14.5907, usually a trustee is tasked with sending out notice that says, hey, listen, either A, I'm stepping down, or B, this trust is coming to a close. I've done everything that I've needed to do at this point. There's really nothing else to do. So I'm just providing you notice and, that the things are coming to an end. So of course, with the law, there's a specific way you have to go about providing notice. So the regular law as it stands now, and as it is in effect now until October 2022, a trustee is required to provide notice. And the general rule is this: a trustee is not liable for his or her actions. But let's face it, this is the law. There's many, many different exceptions to that, right? But that's just the general overarching rule. Now, in the event that a trustee does something that a beneficiary or an interested party may or may not agree with, if you stand by idly and you say nothing and you do nothing, then unfortunately, under the law, you are considered to have actually consented, right, to that person's actions. So if you're in a situation and you have a trustee and you know that the trustee may not be doing things by the book the way he or she is supposed to do it, or it, because apparently corporations are people. So, so with that said, if it's a company that's a trustee, if it's a person that's a trustee, if that company or person is not doing what he or she is supposed to do, or it is not doing what it needs to do, then ultimately you have to speak up, right? Because under the law, it's very clear that if you don't speak up and you just stand by, then you are, deemed to have accepted. And what that means is if you accept it, then you can't turn around and then say, wait a minute, I don't consent to this, I object to this, even though you've said nothing. And of course, as with the law, of course, my aunt is calling me on FaceTime and distracting me. As with the law, there are exceptions to that, right? So if a trustee gets your consent by, let's say you don't act and you are deemed to have consented, but if that consent came from something along the lines of forcing or coercion, as we call it under the law, if there was some kind of coercion, any kind of improper conduct, duress, threats, violence, anything like that, then you are deemed to not have willfully consented, which actually makes sense, right? Because under the law, for you to consent, you have to have that knowledge, you have to have that freedom in order to make the decision on your own. But if you are being forced to make that decision, there is no consent. Okay. So with that said, again, the law says not liable. In addition to that, there is that consent aspect of it. But in order to get proper notice, the trustee will have to inform you of the resignation or the termination of the trust. In addition to that, he or she must provide you, or if it's a company, must provide you with an accounting for the past 5 years. A lot of people don't know that. I've had cases where trustees have refused to do that. And unfortunately, we've had to, seek litigation in order to enforce that. I don't think that that's very good use of people's time, but ultimately, if a trustee is breaching their fiduciary duty, you kind of have to say something. And provide you with an estimate of the assets that are yet to be received, or have not been, that they're holding, but they're not distributing, right? And that's really all about transparency. And most importantly, a trustee has to provide you with their fees, okay? You should always know, I cannot stress this enough, you should always know what your attorney is charging you and what the trustee is charging you. You should always know that. When it comes to estates, you should always know whether or not the personal representative is going to seek his or her fee. You don't want that to be a surprise at the end, because ultimately that creates litigation. And I'm all about avoiding litigation. Nobody wants to have a judge who knows nothing about you and your circumstances make a decision, right? In addition to that, there is a time requirement. The time requirement is 120 days. So in the current law, the trustee has to notify all interested parties. The proposed changes says, well, let's just notify the people that the trustee wants to notify, because ultimately they are, a party to this specific trust. Remember, interested parties under the law means a beneficiary, a representative of a beneficiary, a co-trustee, a successor trustee, or any other person having an interest in or authority over a trust. That might not include a beneficiary. So you don't want to send out 20, 30 letters to individuals who have nothing to do, with the direct impact of the closing or distribution of the assets, right? So you have 120 days from the time that the trustee mails the resignation or the notice. Let's just call it notice. One of the lovely things that we learned in law school, and Tanae knows about this, is the mailbox rule. I always thought the date of receipt is the day that we start counting down at 120 days. No. Under the mailbox rule, and it applies for any kind of action. It does not apply for just for estates and trusts. It applies in our family law cases. It applies in anything. She's laughing. The mailbox rule is a real thing. If you have 15 days to file an answer to a petition, or you have 120 days to contest something, whatever that timeline is, there's always that invisible 3 days that no one knows about. And they think that it is the day of receipt. It is not. Please don't learn that the hard way. Tanae, that is hilarious. You're welcome. Thankfully, in practice, I have not had to learn it, and I don't ever want to learn it, but the mailbox rule is real, right? So you have 120 days to object from the date that the trustee actually deposits this thing in the mail, not the date of receipt, okay? So if 120 days passes and you don't say anything, you don't object, unfortunately, you're consenting, right? And so the trustee can pretty much just do whatever he or she intended to do. But if you do say something and you do consent, if you do file something to say, hey, I object, then ultimately what will take place is you have two options. You can either A, go to court and say, hey, Your Honor, we need your help, or two, you can negotiate with the trustee. As you all know by now, I think you guys know I'm all about negotiations. So some of the proposed changes in the law, I felt like I spent more time teaching you than actually talking about the changes, but whatever. So some of the changes in the law, I'm not going to go through every single one of them, just highlight the really big ones. So the first one, the prior law said each interested party, right? So this is what I was talking about. So now it's not each interested party, it's the interested party for whom the trustee is seeking the release, which 9 times out of 10 is going to be the individual or the representative of the individual or maybe creditors for whom distributing trust assets or removing a trustee or resignation of a trustee is going to directly impact. One of the next changes is that the interested party can now send in a written statement to the trustee that says, hey, I have no objection. Now, under the law, there's been a lot of cases about what constitute a written objection or not. A text message is fine. I don't suggest anyone does that. If you're going to send an email, and then if you want to follow it up with a text message, that's even better. The next possible change is discussion of a possible early distribution, which I think is really cool, because sometimes you want to close cases early. You want to make sure that people can get their distribution and they can move on with their lives. So in this case, the law now has added a possible section where it says that if each interested party that received a report provides a statement that they're A-okay and that there are no objections, then ultimately the trustee can either, can basically do what he or she intended to do, which is, resign or just distribute the property. So again, I think, this clarifying language of, each interested party to whom a report was submitted is trying to make sure that there's no litigation, or there's just not a lot of fees and expenses and so forth and so on that comes with, you know, the possible circus of having individuals be interested parties who are just not even directly impacted by the trust. So with that said, that's kind of just, you know, just again, a brief synopsis. I did not go over the entire bill. There are about 7 or 8 more changes in here, but these I felt, you know, were pretty noteworthy and wanted to discuss them with you. So we will be providing a link to the text on our website. It should be, you know, under this posting in the comments. So you can go ahead and click that. So that way you can check out, you know, the bill's progression. I know right now it's about 50% of the way through the Senate. So, you know, I'm not sure what's going to happen. And but ultimately, I think that there are pretty noteworthy changes that might cut down on some of the confusion that, you know, may come with the law. So with that said, please follow, like, and subscribe. We are on all of the social media outlets. And so Facebook, LinkedIn, Twitter, YouTube. If you guys have any questions at all, please don't hesitate. Send us an email at info@steveslaw.com. You know, I'm doing this to definitely bring some education and awareness, because I think a lot of times, you know, our clients come in and they don't know what's going on. And I think it's imperative that, you know, we attorneys, we get so busy sometimes too, that, you know, we kind of have to catch up. And I think this is a good way to keep me on my toes and, you know, keep me from being stagnant and learning the law with you, and just bringing you some really cool, different content. And yeah, so with that said, again, like, share, and subscribe. I am Marie-Yves, Nadine Jean-Baptiste. I'm the CEO and attorney and all that good stuff of the St. Eve Law Firm. Thank you so much for hanging with us. Thank you, Nay, for your commentary. You are hilarious. Thank you, everyone. Have a great